All right, let's dive into a classic legal showdown involving international trade, broken promises, and the strict rules of contract law. We're looking at the fascinating case of J.M. Wotherspoon Co. Ltd. versus Henry Agency House. This is honestly one of those foundational legal cases that completely shifts how you view a simple everyday business interaction. Have you ever done a favor for a business partner just assuming they'd make it up to you later? Well, as we're about to see, the law has some very specific ideas about what happens when those casual assumptions go south. To really understand how courts view these sorts of business favors, we have to ask ourselves this core question. Can a promise to pay create a binding contract if you were just doing what was suggested? It sounds simple enough, right? But in the realm of contract law, a promise isn't always something you can just take to the bank. A contract usually requires an exchange of value, what lawyers call consideration. But what actually happens when the action is already done before the promise to pay is even made? Section 1. An international trade dispute, England versus Malaysia. Let's set the stage for where this cross-border transaction completely fell apart. When you have goods moving across oceans and multiple parties involved, clear agreements are literally the only things keeping the entire operation from collapsing. We've got two parties in our dispute. The plaintiff, J.M. Wotherspoon Co. Ltd., operating out of England, and the defendant, Henry Agency House, based in Malaysia. The really crucial piece of context to remember here is that both of these firms were acting as agents. They weren't the end buyers, and they weren't the original manufacturers. They were the middlemen. They were the facilitators, just trying to make a complex international deal happen. Here's how it all went down. First, the Malaysian firm Henry Agency House suggested the English firm supply the goods. Trusting the arrangement, the English firm acted on that request and shipped the goods directly to the buyers in Malaysia. But then, disaster struck. Those ultimate buyers in Malaysia simply failed to pay for the goods they received. Because the English firm had already shipped the cargo, this non-payment resulted in a massive, real-world financial loss for them. They were totally left holding the bag. Section 2. The Section 26B defense, searching for a legal remedy. Facing this severe financial hit, the English plaintiff obviously needed a way to recover their money. So they sued the Malaysian defendant to claim compensation. To do this, they had to rely on a very specific legal exception found in the Contracts Act, Section 26B. This section states that an agreement made without consideration becomes a binding contract if it's a promise to compensate a person who has voluntarily done something for the promisor. Normally, if I promise to pay you for something you already did in the past without an agreement, it's just not a valid contract. But Section 26B creates an exception. If you did it voluntarily for me, and I later promise to compensate you, well then that promise becomes legally binding. Section 3. Voluntary versus suggested acts. The crucial detail. As is so often the case in courtroom drama, the entire dispute hinged on one incredibly powerful word, voluntarily. Because the Malaysian firm had initially asked for the goods, we really have to ask, was the English firm's act truly voluntary? The plaintiff didn't just randomly decide to ship goods to Malaysia out of the goodness of their heart, right? They were responding directly to a specific business request from their partners. Section 4. The court's final ruling, defining consideration. The judge carefully examined the timeline, the roles of the agents, and the specific text of Section 26B, and he delivered a profound yet straightforward conclusion. An act done at the suggestion of another party is not done voluntarily. Because the English plaintiff acted on the direct suggestion of the Malaysian defendant, shipping those goods could not legally be classified as a voluntary act. The court ultimately established a fundamental precedent here. A requested act simply does not equal a voluntary act. Because that initial act of shipping the goods was prompted by the defendant, the strict requirements of Section 26B just weren't met, meaning any subsequent promise to compensate the plaintiff for their loss was totally unenforceable. There was no valid consideration. That legal safety net the plaintiff tried to rely on, it just wasn't there. This ruling makes it abundantly clear that under the Contracts Act, the exception for past consideration is extremely narrow. Section 26B applies only to truly voluntary services. If someone asks you to do something, suggests you do something, or prompts you to take action in any way, and you do it without a firm contract in place to get paid, you absolutely cannot later rely on Section 26B to force them to compensate you. The service has to be initiated entirely on your own accord for that specific legal protection to kick in. So, I want to leave you with this thought as we wrap up this explainer. If a business partner suggests you do them a favor today, Are you actually legally protected if they refuse to pay you back tomorrow? The J.M. Wotherspoon case tells us that in the fast-paced world of international trade, and frankly in everyday business, you just shouldn't rely on assumptions. If you are acting on someone else's suggestion, make absolutely sure your compensation is locked in before you ship the goods, because once you act on a request, the law says you are no longer acting as a pure volunteer. Definitely keep that in mind the next time someone asks you for a professional favor.